Hello, I'm April Banerjee, Program Manager for Public Awareness and Education at People with Disabilities Foundation. PWDF was founded 14 years ago with a mission of total integration of people with mental and/or developmental impairments into the whole of society. PWDF is a Section 501c3 public charity based in San Francisco. Our primary focus is on psychiatric and developmental disabilities. Our speaker today, Stephen Bruce, has spent 25 years as an advocate for those with disabilities. After working as an assistant public defender, Mr. Bruce worked for the U.S. Department of Education, Office of Civil Rights, and the Department of Health and Human Services, Office of Civil Rights, Region 9, working with Section 504 compliance issues. He then worked as a senior staff attorney for the Social Security Administration. He also worked as a supervisor for the Government Benefits Unit at Legal Aid before he opened a private practice in Social Security law. He then founded People with Disabilities Foundation, where he currently serves as the agency's legal director. Mr. Bruce received his BA in Economics and Psychology with honors from UC Berkeley and his JD from the University of San Francisco School of Law. He is admitted to numerous courts, including the U.S. Supreme Court, and he is licensed to practice law in California, the District of Columbia, and Florida. Questions can be sent at any time and by email to info@synergize.com on the screen. So please go ahead and send questions at any time during the presentation. And now, Stephen Bruce.
Thank you, April. With mental and/or developmental disabilities, there's been a long history of stigmatizing against this population and causing the population to be marginalized. The mission of PWDF is to destigmatize people with psychiatric and/or developmental disabilities. Recently, statistics have shown that nearly 20% of U.S. adults had a mental illness and 4% had a severe mental illness, not including those with developmental disabilities, and this was in the year 2012. Next. It's really important to understand the impairments in order to serve this population. It's important to understand the underlying pathologies and what remedy you want, which is normally a reasonable accommodation. You need to think of accommodations during the litigation also to allow this population equal access to the court system. The primary reference book, which I'm not going to spend too much time on, is the DSM. We're up to the 5th version, and that is the universal book for people all over the United States and other parts of the world. So psychiatrists, psychologists, and psychotherapists can all be using the same diagnostic criteria. And the practitioner has to know the diagnosis that their clients have. Now, under the most common diagnoses, it's really important to know more than just the name. In other words, there's a list we have up, including psychotic disorders, mood disorders, such as bipolar and depression. Anxiety disorders covers PTSD, OCD, and we have cognitive disorders, which are not the same as psychotic disorders or mood disorders, disruptive disorders, intellectual disabilities, the autism spectrum disorder, and other DD or developmental disabilities. So you cannot think of in terms of just severe mental illness or psychiatric diagnosis and expect to accomplish much. Unlike intellectual disabilities and a lot of physical disabilities, many mental diagnoses cannot be measured by quantitative testing. Now, this is true of psychosis, the most common form of which is schizophrenia, or bipolar disorder. It isn't like measuring someone's intelligence, cognitive abilities, and it's extremely important to be aware of how are you going to advocate, proceed through, whether it's a hearing or a trial, um, uh, uh, what are the bases of litigation and what kind of experts you may end up using. I mean, briefly, I want to state there have been some cases. The Olmsted case, which is on your screen, did go to the Supreme Court. And this was in '99, and this was in the state of Georgia, and it has to do with Title II, the Americans with Disabilities Act, which required the most integrated community setting possible. The two women plaintiffs and respondents at the Supreme Court were kept in a state institution for many, many years. And the Olmsted case went into, at the request of the state of Georgia, factors that they can use as a defense, such as economic and other factors. Now, unfortunately, many disability rights and advocates and other advocates through the present, it's the year 2015 as we're giving this workshop, will not represent this population on their own. Recently, or I should say maybe 10 years ago, there was a class action against the Social Security Administration. However, the population with mental impairments was dropped in favor of blind. That's not to say they didn't or don't discriminate against blind people by not having auxiliary formats, but regrettably, and one of the reasons for this and other workshops like this is to represent those with severe mental illness on their own without having to attach or ride the coattails of another population. The stated purpose of dropping the people with mental disabilities was to pin down the law, and in one perspective it's understandable, but 10 years later it doesn't look like anything has changed. In this workshop, we're going to focus, by example, on 3 federal cases involving a lack of access, program access, and the cases were all had the Social Security Administration as the defendant. So it wasn't to get benefits, although it certainly included those kinds of things. But post-entitlement, post-eligibility issues that came up during the process, such as work reviews and post-eligibility determinations for those on SSI disability, SSI being the poverty program. Now, I'm going to briefly say this. The reason we used Section 504 was because the Americans with Disabilities Act does not apply to the federal government. However, the law for Title II of the ADA and Section 504 of the Rehabilitation Act of 1973 are the same. So I'm going to be using them interchangeably with the understanding that you cannot sue a federal agency under the Americans with Disabilities Act, but under Title II of the ADA, you can sue states and other governmental entities. The symptomatology, underlying pathology, and diagnoses, as I said before, are very important. In the first example, the plaintiff's name is Timothy Gibler, who was high functioning intellectually. He was not cognitively impaired. His psychosis was generally described as either not otherwise specified or schizophrenia, depending on who was doing the cases. But his symptomatology, which must be understood, which is relates to a functional limitation, which in turn relates to what accommodation he needs, had to do with him viewing the world or things happening to him within the world as an emergency at all times, even if in reality there was no emergency going on. He, like the other two examples, had a depressive disorder and tried to commit suicide certainly before the litigation. During the litigation, the suicidal ideation and or attempts continued, but at no greater rate than before. So the next case we're going to be using, Mr. Terrence Davis, his diagnosis is paranoid schizophrenia. I'm saying with or without cognitive impairments because in the first 50 years of his life, he never had cognitive testing. And when you're talking about advocacy and litigating in court, you need medical evidence. And you cannot say just because he sounds like he's his intellect isn't high or his reading level is sort of low. In fact, he says he can't read. You really need the medical evidence to say that. In other words, he at the time of his trial, when it came time to choose experts, I had to get the psychometric testing to establish his ability to read, write, do arithmetic, and the answer was with him 5th grade, according to the testing. The final example case that we're going to discuss today, before we get to employment and housing and other areas of law, is John Doe. That's not his real name, of course, but he has autism with psychotic features, a severe intellectual disability, and severe depression with a lot of suicidal ideation and attempts. Maybe on average 2 attempts a year, I mean, ranging from trying to drown himself, electrocute himself, hanging himself, drinking laundry detergent, and that's those kinds of symptoms the advocate or attorney has to be aware of, because you may be getting involved in a multi-year litigation, and it's really important to understand by talking to the client what the litigation involves and what accommodations may be necessary even during the litigation. So the accommodations with more specificity I'll touch upon in a few moments. I just wanted to go over some barriers that may have led to this problem of unequal advocacy of the population with severe mental and or developmental disabilities. We have a few stereotypes listed on the slide, and basically I don't want to spend too much time on these, but people assume, as I alluded to, that if someone has severe mental illness, they either have an intellectual disability or very limited cognitive functioning, and that is not necessarily true. There are a lot of high intellectually functioning people who have a psychosis or a mood disorder like bipolar. So it's a stereotype, as is that people of this population are violent and unpredictable. There's been a lot of references lately since we've had, I guess, news and press about shootings around the United States, whether it was Virginia Tech or Colorado or other places, is it true that people with mental illness are more prone towards violence? And there is empirical evidence, and basically the answer is no. Now that does not mean that they, like others, cannot or would not commit violent acts, but it's just a generalization. That is not true. Moving to the next slide. Incidentally, you don't have to wait till the end to email your questions. We have someone here who should be monitoring them. I just ask you wait maybe till I finish a paragraph or so. What we have to think of, and it comes up in court when one is litigating, is that everyone has a right to live independently. Now, this is very, very fundamental. And the right to use the judicial system is also a fundamental right. And you get questions coming up about, can these individuals or some of them withstand the pressures of litigation, and you need to know how you're going to deal with this kind of thing. So when you initially are talking to your client about their disorder, you need to understand what you're talking about in terms of asking them medications, the dose of the medications, and you need to get a good understanding for their functional limitations. You need to know who their psychiatrist and or psychotherapist is, and the facts of the case. And there's no such thing as being able to advocate for this population without having an underlying understanding of the pathology of each individual's disorder, because that's the only way you're really going to know what remedy you want, which, as I've said, is going to be reasonable accommodations. In fact, under the, if you're suing the federal agency, Congress has never waived immunity for monetary damages, so injunctive relief is the only remedy you're going to get for these individuals. The process needs to be explained to the client or the plaintiff, whatever you're calling them, so they understand what it takes in terms of their own support framework to engage in a multi-year litigation process. So, for example, if you're suing the Social Security Administration over barriers to a lot of their post-eligibility and or entitlement processes, you really need to know who comprises their support framework, and it's not the same with everyone. Some of them will have a psychotherapist, family members, and or with a DD individual, an independent living skills trainer or coach. Some may have a job coach, but only at times. You need to be able to communicate with your client. If you need assistance of others who are already there in support of your client, whether provided by state or other agencies, you need to have a working relationship with these people who constitute what I call the client support framework. And you need to understand that as the attorney, you will become part of the support framework, at least for the period pre-litigation and litigation, and even post-litigation, if the court retains jurisdiction, as happened in the Doe and Davis cases. Now, in the handouts, the settlement agreement for the Doe and Davis cases should be available to you, and we did get a lot of accommodations based on, of course, their limitations as is derived from their disorders, and the court retained jurisdiction over a period of years. So you need to really work with the framework and be aware that this is going to be a long process, and even after the judgment, or if you win a favorable settlement with the court retaining jurisdiction, you have to understand if it's working and or what parts aren't working, and that should be provided for in the remedy that you're seeking. Now, on the next page, know the pathology. Client fragility is used as an excuse by some attorneys not to represent. So in the three examples I'm using today, they all live month to month. In other words, whether they're on the poverty or not the poverty program of Social Security, disability, losing benefits, or being sent overpayment notices is extremely distressing because they don't have enough money for the next month's rent or food. Now, all three clients that I'm talking about today have tried to kill themselves, although that is something you need to be aware of. It did not happen at a higher frequency during the litigation. It may have even been a lower frequency, but you need to be aware of the suicide attempts and ideation, because you need to factor that into your representing this population. Knowing that they're going to be under certain pressures in litigation, like from opposing counsel, who may, as the expression goes, try to push them off the cliff, is something you have to take seriously, but it's not a reason to refuse to advocate for this population. So you want to explain to your client how the system works, and if there are depositions, what it is, and you have to think about what you're going to do for accommodations, for example, for the depositions themselves. But in this case, I don't want to spend too much time under the facts of the case, because Social Security has very complicated work incentive rules, and they're not the same for the two programs, the insured program known as SSDI and their poverty disability program known as SSI. So they have two sets of rules, and each individual who's on both programs will be bombarded with double the notices than they would if they were only on one. And that is often daunting and overwhelming. But the attorney really has to have an understanding for how these rules operate, and if they operate in a disparate or discriminatory way upon the disabled individual. I use the word effective communication in terms of between attorney and client, but effective communication actually is the operative legal word in the Section 504, and therefore the Americans with Disabilities Act, regulations. Now, effective communication does not just apply to sensory systems like seeing and hearing. It applies towards this population that we are talking about today in this workshop. And that is an issue, or the main legal issue in the cases, is the agency, and in this case it's the Social Security Administration, effectively communicating with the individual, so that the standard is, are they communicating in a way so that the individual can understand and respond. It's sort of like the due process definition is someone on sufficient notice to enable them to respond to a notice, and you just need to think of it, can a reasonably prudent disabled individual respond? So that concept of reasonably prudent disabled person is the legal standard in due process cases, but it's also an important standard in discrimination cases under the ADA, and you need to be thinking about that in terms of what remedy you're asking for, what kinds of accommodations will enable your client to understand, and in these cases, one was due process, but two were Section 504 due process, what kind of accommodations will give them equal opportunity to the Social Security programs. Sometimes the words meaningful access are used, but the bottom line is not to get caught up in meaningful access versus equal opportunity. We're talking pretty much about the same thing. Now, I'm going to go into the facts of the case because we need to have a framework to understand the dynamics in any case, but in these cases, all three plaintiffs were ceased from their benefits based on work reviews. And the Social Security Administration is increasing the quota per district office or field office across the United States. It has been every single year. It is, there is legal justification in that people who can engage in what's called substantial gainful activity or competitive work are not disabled, but there's a lot of political pressure to get people off the rolls. And basically all we're asking for, if they're going to do that, they need to do it even-handedly, and that has not been happening. So when these work reviews take place, the people who do them have no medical training. They're at the Social Security, it's known as the local field office or district office, and there are certain questions, I guess the answer is on this slide. It says, does SSA consider the medical condition during the work review? The answer is no. One case, Mr. Gibler's case, he had been during the work review in a lock-up psychiatric ward in the hospital, but Social Security found that he was able to work full times at all times during the work review, even though he was in a lock-up psych ward and even though they knew it. So the Social Security Administration used to take that into account, in other words, medical records, and now their position is, at least through the present, that they will ignore medical evidence. Now, I'm not trying to put down the claims representatives. They really don't do medical. The state agencies do that. In other words, Social Security contracts with each of the 50 states at DDS, Disability Determination Services, to do medical reviews. And the local field office which does the work reviews has access to that, but Social Security does not want them to send the files to your state's DDS, even if it seems pretty obvious that they need to. In other words, in these cases, for example, Mr. Davis, who has schizophrenia, spent 1 year undergoing a work review by a supervisor at a field office, and he never knew and never asked what the disability was, schizophrenia. This may sound absurd, but it is what has been going on. Social Security does have a coding system since around '96 in their computers, 2 codes for each person, primary and secondary disability. Now, whether the individual in the field office looks at those and has any understanding of those is a different question. The answer is they usually do not look at those, but they're there and they're available, but they're simply not used, and certainly weren't in the 3 cases that I'm talking about. Now, we have a lot to cover, but I still need to go over the Davis and Doe cases were consolidated cases, and as I said, the work incentive rules are very complicated, and the person who's assigned the work review does not have any medical training, and in these 3 cases, and in others, they don't look at the codes and therefore don't know the disability, keeping in mind that we're talking about invisible psychological disabilities. They know things, I mean, when you talk to them, like a wheelchair may not fit through a door that's not wide enough, or if someone's blind, well, after being sued, they will give what's known as an auxiliary format, such as audio or braille. That's only very recent that happened, even with the more simple black and white cases like hearing impaired, where they'll bring in a signer. That's only within the last couple of years, or blind to, they did not want to send an audio CD, now they do. But in the area we're talking about today is the population with these invisible disabilities, and I'm just going to give you one example so we can continue to move on. One thing they have to look about when they're determining if the person is able to or has been engaged in substantial gainful activity, which means work or competitive work employment, is if they have any IRWEs. IRWEs, I-R-W-E, means impairment-related work expenses. And you might wonder, how is someone who doesn't know what the impairment is going to know if they have impairment-related work expenses? And it's a good question. I wondered about that too. How would they even discuss it with the beneficiary of the Social Security checks and medical benefits if they didn't know what it was? And this is a problem that happens at all levels in Social Security, even at the administrative law judge level. They're basically told not to look at medical, even if it seems and is impossible, as in that example. So these are complicated rules. I was a little surprised that the U.S. Attorney who represents Social Security said in court pleadings, that they are complicated, but no one else understands them either. And it was a little bit someone's handing me a piece of paper. Apparently it's a question that was emailed, and it's I don't mind being to stop to answer questions. I think the interactive discussion part of these workshops are important. The question is, do you have strategies or steps for determining whether a potential client has the capacity to retain an attorney? Well, let me say two things about that. I'm going to assume it's not financial capacity, since in the cases I'm talking about, we don't charge anyone. Of course, we are a nonprofit. So I'm going to interpret this question as if, do they even know that their rights are being violated and that they need a lawyer? First of all, I've said the work incentive rules are very complicated. Certainly, the discrimination procedure administratively is not announced by Social Security, and the answer is to this question is no. A lot of people have no idea that they're being discriminated against, because they're sent notices, and there's a report called the Work Activity Report, or Form 821, which we incidentally got changed nationwide because it didn't cover anything but physical disabilities. And the answer is no, and there needs to be more outreach from a state, federal, and local communities, including the government, advising people that these issues exist, and there are statistics. I'll say this, it's from memory, but not even counting people with developmental disabilities, the proportion of people ceased during a work review with a mental disability was approximately 65% versus 42% of the people who do not have mental disabilities. So that's a good question, and the answer is very important. The answer is no. There is an administrative form that Social Security, which became an excuse me, independent commission in 1995. I believe in the last 2 years they have a form now, other than HHS's old form, to file an administrative complaint. But I can't spend too much more time on this subject, but it is important. That complaint actually goes to Social Security's attorneys, the same attorneys that defend the agency in court. They did get rid of their Office for Civil Rights, and it would be very unusual if they upheld any discrimination complaint that was filed administratively. And in fact, you have to exhaust administrative remedies to sue in court. But it's important to note that they have steered the system where no one's ever going to get or no one ever has really gotten accommodations, because again, the attorney from the Office of General Counsel that works for Social Security is the same attorney that has to defend them in court. So you can just use common sense. Are they really going to say you've been discriminated against and offer a remedy? Because that may indicate liability, and their job is to defend the administration. Moving along, getting back to these cases, I just want to make a few points, because I keep saying these work incentive programs are complicated. You have something called an unsuccessful work attempt, which means those earnings are not countable against the Social Security beneficiary. That means when they're doing a work review, they can't count it against them for terminating them because they're working. So there are two sets of rules for an unsuccessful work attempt, also known as a UWA. One is up to 3 months, and the other one is 4 to 6 months. So they can categorize a work attempt so long as they had to stop working based on their disability as an unsuccessful work attempt and not count it against the disabled individual. At the same time, there's income averaging rules, which means that over 12 months, they take the total earnings and divide by 12. It may have been thought that this would help the individual who made earnings in just a few months to lower the amount below the threshold level. This year it's 1,090, but for about 20 years it was 500 gross a month before it was considered SGA, or work that means someone's not disabled. So as you can see, there's a conflict here. If they're going to income average, it may result in someone not being able to use an unsuccessful work attempt, which happened in the Davis case. And I'm going to give a brief example of that. They write to the employer to find out if they've been subsidized by the employer or unsuccessful work attempts. And most of these people aren't going to tell their employer that they have schizophrenia because they won't be able to get another job as a practical matter. And Social Security relies on a form letter to the employer, and since the person during the work review doesn't know anything about schizophrenia, and the employer was never told the reason the individual left was based on disability, they adjudicate it the wrong way. They say the person left, but it was not an unsuccessful work attempt because it was not based on disability. There are a lot of other examples like that, but that is the kind of thing that happens. And again, to whoever asked that question, do these people really have the capacity to understand the dynamic? They do if you explain to them, certainly, but they don't otherwise. And it's not just capacity, it's because they're complex rules and they're not explained by the administration. So we are talking about the other plaintiff in this case with consolidated plaintiffs, John Doe, the one with autism with psychotic features, major depression with suicide attempts, intellectual disability, who lived in an ARC residence, ARC. They're in all the states and they're national for the people who are developmentally disabled. And he certainly had a support framework, but he also had a lot of special circumstances in his work, which may have really been sheltered work or supportive work and not the kind of work Social Security could use against someone. But to find out, you'd have to talk to his independent living skills trainer or psychotherapist or one of several other people to understand, and his employer, whose deposition the other side took. And then it became even more apparent, at least to defendant Social Security Administration, about his limitations, special circumstances, and IRWEs, impairment-related work expenses, that he had to enable him to work to the extent he did. Now, I want to focus back on the litigation. I did get reasonable accommodations during the litigation because they did play hardball in fighting this, and I guess, you know, every lawyer has a right to do that. That is the position of the Department of Justice, where the United States attorneys are, who represent these or any federal agencies. I asked in court, in open court, the judge for accommodations during the case. I asked that they have extra breaks during the deposition, that they not be conducted in the United States Attorney's Office, and that they have, or at least one of them, I may have asked for both, but one of them really needed a support person during the deposition, so long as a support person was not going to participate in answering the questions. And the judge said, well, what kind of support? And I said, well, psychological support. And so we got those reasonable accommodations for the plaintiff's depositions. And as some of you may know, smoking cigarettes is associated with schizophrenia based on studies. So taking a cigarette break could apply to anyone, but that came up in the same discussion about leaving the building, which was the federal building here in San Francisco. But it's just an example of why you need them and how you may need to educate the court to why you need accommodations. I mean, this individual with autism and intellectual disability will easily submit to authority and go along with someone, whether it's a Social Security office or their lawyers in court, the United States Attorney, in submitting to authority. They will sign and say what they're told to do. That some people, to some extent, but you really have to be aware of that. In other words, of your own client's limitations based on the disability. We also got a protective order because you have to talk to your plaintiffs for a while to see if they're willing to be plaintiffs with full knowledge. And because of the concerns about keeping his job or getting another job, the identity protective order was really not only to proceed under a John Doe plaintiff, but also to not use any facts that could lead to his identity, such as where he lives, place of employment, etc. And that's really important. If that's what your client wants, and you have a duty to ask, because you need to do what's best for your client, that is something which lasts forever, only because I asked the judge when I wrote the motion to delete the 10-year sunset provision. In other words, where the individual's identity normally could be released in the local rules of court. So you have to really be aware of that kind of detail. Now, the depositions, I've already talked about. Basically, they were helpful. And we did get through, although I have to say it took at least 4 sessions. In the federal system, you get 7 hours. But they would have been hard-pressed due to extra stressors that many of this population has to sit down for 7 hours. And there was improper conduct by the other side, like using the R word, retarded. Even though it's been illegal since President Obama said so by signing it into law since the year 2010 from the executive branch, they used that word, and I made a big deal about it because, well, no one likes being called retarded. I compared it to using the N word, but just because they're part of the United States Department of Justice does not mean they won't stoop to a low level to try to agitate your client or push them off a cliff. Now, that is not a reason not to represent them. You just have to be aware of these factors and aware of what to do, even if it is in the middle of a deposition. Now, as I've said before, and this workshop is sort of short, so I want to run through a few things. psychosis does not mean someone is cognitively impaired, and if they are, you're going to need the evidence. So at the time I retained an expert, I had to send the one with schizophrenia for testing. He said he couldn't read, but the RAT testing, WRAT 4, Roman numeral 4, does test for spelling, reading, arithmetic, and of course the WAIS, WAIS 4, is an IQ test. Although these don't apply to, as I said, psychosis and mood disorders, don't assume because someone may sound a certain way that you don't need the medical evidence for the trial and for your expert, who is going to be a psychiatrist in this case, in addition to the current treating psychiatrists and or psychologists and psychotherapists and other people like independent living skills trainers who are already involved with your client. One thing that happened in two of these cases was surprising. Social Security said these plaintiffs are too fragile, and therefore the judge should dismiss the case. Now, what I said was the court can appoint an ad litem, and the court took that position and did not agree with that opinion. But they'll do whatever they can to defend against the case, so you really have to be aware. I don't suggest people get ad litems or conservators. These individuals, like anybody else, have a right to go to court to assert their rights. If it comes to a point where that protection is necessary, the judge and the state judges can all do the same thing in terms of conservators or guardian ad litems for the court proceeding. But I would not try to avoid communicating with my clients by saying, well, I'm just going to get someone else appointed by the court. They should have the right to live independently, which includes the right to go into court, whether it's a settlement conference where the party has to be there, or any other part of the proceedings. And I think we all, as disability rights advocates, have to keep that in mind, that they should be treated like everybody else. We did not use any kind of an ad litem during this proceedings, but in some situations, if it comes to that, just be aware that you can still proceed with the case. You just need to be aware of that possibility. I'm just moving forward to remedies, which is on page 27 of the PowerPoint slides. Reasonable accommodations you really have to think about. And in the settlement agreement, which are in the handouts, there is a list, not just for training, but having one person and a backup person assigned to each plaintiff so they can develop a rapport, and also things like getting a written summary of what transpired, because what transpired may lead to a termination of benefits. And it's important to look at, I think it's a 12-page agreement, but the list of accommodations, because it may not be that obvious up front, just based on whether it's testing and neuropsych testing, but what you need for your client to have effective communication. And those two words are the operative legal words in these cases. So in the PowerPoint, I'm not going to read them, but we did list examples of reasonable accommodations under remedies on page 27, and you should read that because it's really important to be able to articulate what you want as a remedy. This litigation took up to 6 years, and certainly you would want to know what it is that you want from the other side, or and for the court to order. The court did agree to retain jurisdiction, and basically at this point in time, it's both sides are threatening each other. They didn't want their practices, procedures revealed. They wanted their depositions kept secret. And we wanted to make sure they complied with all the accommodations, at least until they reached their certain age related to retirement, so they would have a fallback of benefits, not based on work-related factors, as opposed to proof of age. So I want to, and we're not going to have much time, but just mention a little bit about other areas, employment, which is page 30 of the handout. And in employment, a lot of us already know that someone has to be a qualified individual with a disability and needs to have a substantial interference with a life factor such as thinking, walking, talking, and which is always going to happen in Social Security because of the restrictive definition of disability in that case. When I went to the Veterans Administration in Palo Alto, California, one of the managers asked me a very good question. She felt that her employee had a mental disability. She knew both the clinics and the hospitals were within a block or two on this gigantic campus. And she also was told, as most employers are told, that you can't ask someone about their disability unless they're requesting a reasonable accommodation. So the question to me was, the VA changed the job description. The employee of over 10 years couldn't do the new job as described. She was not allowed to look at his medical chart, and she was planning, therefore, on suspending him without pay for 6 weeks as the appropriate disciplinary action. Now, different people may disagree on this question, but I think in that situation, she would have been better off talking to him, even if it was through an EEO person. And all federal agencies have the EEO people. They're the ones you go to if you need to file an EEO complaint. It could have been through a union representative, or it could have been directly if you really don't know for certain because it's invisible, but are pretty, but feel that way. Maybe the manager knew he went to psychotherapy every week because he took off from work. It's not clear how she knew, but she strongly felt that way. And it's going to be an obstacle, really, since HR and the lawyers for the employers say the bottom line rule of no disclosure of disability except when asking for reasonable accommodation. My opinion is, although that's true, she seemed to be on some notice because she said so, that he was disabled, and the correct course of action would have been to bring it up in a private meeting, perhaps with someone there, like an EO counselor or other representative. But it was an interesting question that I wanted to share during this hour, and I'll do the same really with a housing issue. When we have, or those of us who are participating in this workshop sometimes have housing issues where there may be an eviction, and usually with this population, the eviction is based on a nuisance ground. And we need to understand that there are reasonable accommodations that apply to tenants who are disabled and fit the criteria under the Fair Housing Amendments of 1988. And it's not just service dogs, but it could be padding in the apartment so noise won't affect other people. Last few years, it seems that having a third person I should say, second person in at times, even if the lease only calls for one, could really help in reminding the person to take his or her medications. So we need to keep an open mind about accommodations and the scope of accommodations, and that is on page 31. As most of you know, or some of you, the Department of Justice changed the service animal rule to leave out everything except dogs who can perform a task, and you really need to look to housing laws in your state. In California, it does not just apply to dogs, and it is still true that emotional support is sufficient. Now, that is not what the new justice regulations say, the ADA regulations about. It's actually dogs and ponies for some reason, miniature horses. But I just wanted to touch upon other areas other than program access, employment, and housing, because it's the same population, and a lot of the things that applied in the litigation we have done in against the Social Security, there are a lot of related concepts, but that would be another workshop, which we do on employment and housing. So it's now about the end of the workshop. This is being broadcast without a studio audience. It's the first time you've done it without an auditorium full of people, but we hope to reach a broader audience statewide, nationwide, and beyond if possible. So thank you very much. If you have any questions, the email to use is info@pwdf.org. That's info@ P as in people, W as in with disabilities, which is a D, and F as in foundation.org. Thank you very much.